You're listening to Florida Matters, live from the Performance Studio at WUSF in Tampa. I'm Matthew Petty. Abortion is a polarizing issue, but whatever your opinion, if you're a Floridian voting this November, you'll have a say in whether the right to an abortion is written into the state constitution. Coming up this hour, we've created space for conversations on both sides of this controversial amendment. It's not a debate, but you'll hear background to the proposed amendment and how it could roll back Florida's current ban on abortions. We'll also dive into the details of constitutional law. You'll hear from someone who's working to help people access abortions, and then from a long-time opponent of abortion. And this is a chance for you to hear directly from people involved in this political debate. Like voters in 11 other states this fall, Florida will have the chance to vote on abortion access, in this case through a constitutional amendment. But since May, Floridians seeking an abortion have faced an added hurdle, as have medical practices and groups that support people who are seeking abortions. Today, the procedure is banned beyond the 6th week of pregnancy, with some rare exceptions. That's after the Florida Legislature replaced a 15-week ban that had been in place since the U.S. Supreme Court overturned Roe v. Wade in 2022. Well, Brittany Fontenot is the president of the National Abortion Federation. The group represents abortion providers, and its hotline is the largest patient assistance fund for abortion in the country. Fontenot says in the first half of this year, the hotline was spending more than $6 million a month on abortion appointments and thousands more on travel support.
The reason why that jump is so big is because Florida really served as a critical hub for abortion access, not just for Floridians, but for the entire southeast of the country.
Before, the Federation would cover the cost of 50% of eligible patients' abortion appointments, but as of July 1st, it's only covering 30%. Fontenot says they had to make that cut or they would have run out of money. And here's Amber Pugh, who works for the National Abortion Hotline, the largest patient assistance fund in the country. She works with callers from Florida and helps them with financial aid and travel support, and it can be a tough job.
People are terrified with these bans. They're really scared that they're not going to be able to get the care that they need and they deserve. So oftentimes, we're one of the only people that callers choose to share that they're getting an abortion with. So often, we're also providing that emotional support through this process.
And the two people you just heard spoke to WUSF health reporter Stephanie Colombini, who's been reporting on the impact of Florida's law changes around abortion access. Well, I want to welcome to the stage Catherine Vaughn. She's a journalist with Axios Tampa Bay and has extensively covered Florida's legislature, in particular the abortion issue. Catherine, thanks for being here first. Can you clarify what the rules are right now around abortion in Florida? What's allowed, what's not allowed?
So right now, Florida has a 6-week abortion ban, and there are exceptions for the health of the mother and also the child that are part of that are carved out in the ban. But the ban went into effect. It was signed into law by DeSantis last year, and there was a lag time for it to go into effect because there was still a legal challenge happening against the previous 15-week ban, which we were under before the 6-week ban went into effect. And the Florida Supreme Court had to rule on the 15-week ban before the 6-week ban could go into effect. And depending on how that ruling went, the 6-week ban would either go into effect or we would stick with the 15-week ban that we already had. So the way that the Supreme Court ruled did trigger that 6-week ban going into effect with a 30-day lead time, and that's where we're at right now.
There are some exceptions, though. Can you explain what those are?
Yeah, so there's exceptions to protect the pregnant person from great bodily harm or death, and there's also exceptions for the health of the unborn child.
Now, can you walk us through the proposed amendment? What would it mean for people seeking abortions in Florida?
If it passes, it would make abortion legal up until viability, which is around 23 to 24 weeks of pregnancy. And there is one exception in the amendment. It does not change the legislature's constitutional authority to require notification to a parent or guardian before a minor has an abortion. But otherwise, yes, it would make the procedure legal up until about 23 to 24 weeks of pregnancy, which is actually what Florida had not too long ago. The 15-week ban went into effect a couple years ago, and now, like I said, we're at 6 weeks. But viability was the standard under Roe v. Wade, which obviously has now been overturned. But Florida had the same standard up until a few years ago.
Now, what have supporters of the proposed amendment been telling you?
So, it's about a very, very deeply personal health decision that should be between a woman and her doctor, and that this is an opportunity to clarify that and keep those decisions private. And it's about bodily autonomy and women having the choice, as opposed to now with a 6-week ban, there aren't as many options.
There is plenty of opposition to the amendment too. I want to play a little bit of sound here. It's Bishop Gregory Parks with the Diocese of St. Petersburg, and this is from a video in which he urges people to vote no on Amendment 4.
You'll be hearing a lot of mixed messages about Amendment 4 in Florida. I urge you to be informed about Amendment 4, a misleading and dangerous proposal that would enshrine unregulated abortion in Florida.
So Parks goes on to list reasons why not to vote for Amendment 4. He says it will put women at risk, eliminate parental consent, allow for what he calls, quote, extremely late-term abortions when a child could survive outside the womb, end quote, and weaken requirements for who can approve abortions. And it should be noted that supporters of abortion access and doctors who provide that care say the restrictions themselves are jeopardizing women's health. So, Catherine, what else can you tell us about the opposition to this amendment or this proposed amendment in Florida?
Well, the state challenged the language of the amendment. That's why the Supreme Court had to decide whether it could go on the ballot. And the challenge coming from Attorney General Ashley Moody's office was that the language was misleading and that Floridians don't know what viability means necessarily, and that argument obviously didn't win over the court because they ultimately decided the amendment could go on the ballot. So that's been an issue. And then another issue that's come up recently is the fiscal impact statement, which goes on the ballot basically telling voters, hey, if you approve this, this is public money that might be affected, that might need to be spent, and so there's a battle going still now about what that fiscal impact statement should say. At first, it was indeterminate, but the state has made the case that it should include more information. Specifically, that if the amendment passes, the state will challenge it in court, and that there will be legal costs associated with that court battle. So they think that that is something that voters should know before they vote for it. And also that potentially, public money could be going toward abortions and things like that. But obviously, those are legislative decisions that will be made during this legislative session. So yes, a lot of it, the main issues from the opposition are clarity of language and, how much information to provide voters about the potential financial impacts.
Now, for supporters of this proposed amendment, the success of it in November is far from guaranteed. So what does it actually need to pass?
So in Florida, constitutional amendments need 60% of the vote, not just 50%, it's 60%. And they're gonna, the amendment folks and are working on, turning out the vote, making sure people know about this, and that they go to the polls, and ultimately, that 60% threshold is needed for this to go into, to pass. Now, after that, it will also, as the state has suggested, there will, be a legal challenge that occurs, and that it's unclear how that might affect it actually going into it being implemented in the state. And then also the legislature, as we've seen with other amendments, such as the the Amendment 4 a couple years ago, restoring voting rights to people convicted of felonies. The legislature has the opportunity to weigh in on implementation, and we've seen cases where the legislature has stopped implementation or partially stopped implementation. And so, just because the amendment passes doesn't mean it's going to go into effect immediately. There are still several things that could happen and challenges that could come up. But for the ball to get rolling at all, it needs that 60% vote threshold.
Well, Catherine, stay with us, and I want to welcome Bree Wallace up to the desk if we could. Well, Bree Wallace, you're with the Tampa Bay Abortion Fund, so just tell us what your organization does and what was the impetus for its creation.
Yeah, so we remove the financial and logistical barriers that people face towards abortion access, which is mainly clinic costs, and now with the 6-week ban and the 15-week ban, travel. So booking flights, hotels, childcare, ride shares, and really this started back before Roe even happened. We were created in 2017 just because there was a need in Tampa towards abortion access and covering clinic costs for people.
Was there a discussion back then about the potential for the US Supreme Court to roll back Roe? Was that something on the minds of the organization?
I have only been with them since 2020, but yes, it was discussed a little bit in 2020, and then of course in 2022 when the decision came out. And I think it was always in the back of our minds that you're never safe. Roe wasn't doing anything for us. We knew it could crash at any second.
So can you give us a sense of who is seeking abortions in Florida now, and I guess kind of what goes into that decision-making process for those folks?
Yeah, I think any and all people are seeking abortions. I think the people that we assist most at the time are people who are low income or even unhoused. But now with a 6-week ban, it really goes higher than that just because it can be so costly to leave the state. A lot of clients, it's around $2,000 to go out of state between clinic and travel. So really it affects everybody now.
Catherine, if I could bring you back in for a moment, how does that kind of track with what you're seeing or the reporting that you've done with folks who provide abortion access in Florida in terms of people having to leave the state or looking elsewhere?
Yeah, I've certainly heard that that the logistics and travel costs associated with getting an abortion out of state are tough for a lot of people, and Florida was a haven to much of the South for abortion access. And so without Florida as an option, not only are Floridians having to leave the state more, but other residents from southern states as well. So it has affected that access in the South. People going to places like North Carolina, up to New York City, over to Illinois. I talked to a Chicago Abortion Fund official who said that they need to make a lot more money, basically get a lot more donations to support the influx of people that they were expecting from the 6-week ban in Florida going into effect. So it's certainly in line with what I've heard as well.
Bree, how has that 6-week restriction implemented earlier this year kind of changed the work that you do? Has it made it tougher to connect patients with clinics, for example?
For sure. I think our local clinics have been great at getting people in very quickly, especially with just 6 weeks being so urgent and so many people not knowing they're pregnant before then. I think going out of state can be a lot tougher. The whole South right now is going to the North, so there's definitely weights and barriers in place there. And then, of course, you touched on the national funding cuts earlier, which has been pretty bad for the funds. I think we pledged over $100,000 in July, so it's been very costly.
When you talk to folks who are, opposed to looser restrictions on abortion, one of the arguments against it is that they would permit so-called late-term abortions, and that's not a medical phrase, but in the experience of the work that you've done, how common are abortions after the first trimester?
I think it's definitely fewer than, of course, first trimester and second. And a lot of the times it is health related and sometimes it's not. And that's okay as well. I mean, no matter how far along you are, it's your choice. But people do usually make it in the first trimester. And most of the people I see who go out of state are for health related reasons that they couldn't be seen in Florida for.
When you think about the changes that have rolled out, since 2022, the 15-week ban and then the 6-week restrictions this year, what kind of conversations are there being had around these new rules? I mean, is it a concern legally for your organization?
At times, yes. But everything we do is within legal ruling. We help people under 6 weeks here, and then we help them go out of state if they're over 6 weeks. And then, of course, there's the topic of self-managed abortion, which we are all also within legal lines whenever we talk about that. But it can be hard. We do see a lot of governments, especially in the South, try to enforce laws that have to do with just crazy abortion-related things.
Mm-hmm. Catherine, when you pull out from Florida, what does that look like for other states? I mean, is that a conversation that these organizations are kind of having state to state in terms of what the options are and what the kind of legal risks may be?
Well, speaking about of self-managed abortions, that is something that's been kind of an interesting state-to-state issue. There are states like I know there's a group like in Massachusetts that is sending mailing abortion pills to states with bans, and they're saying we can legally do this because we have shield laws in place in our state that protect us from prosecution. And then states with bans are saying you can't do this because we have an abortion ban that prevents people from getting an abortion after a certain point. So it kind of sets up this very interesting legal question of whose state law will prevail in that debate. So I think there's some very interesting state to state tension there too. And yeah, I mean, I've seen reporting from my colleagues in North Carolina about just how much preparation abortion advocates and healthcare providers were doing up there to prepare for the influx of patients from Florida. And yeah, it creates a very confusing and chaotic situation when you have such different restrictions, state to state, and you could have two states next to each other with very different rules. So those are things that'll probably have to get worked out in the courts.
And just to clarify, what does self-managed mean?
Self-managed abortion, it's when you do it in your own home. So you take Miffy and Miso, which are pills, but you do them not in a clinic setting in your own home.
Mm-hmm. I want to ask too, Bree, about the exceptions to the 6-week ban. Those exceptions are for rape, incest, where the life of the mother is at risk. Do those exceptions go far enough? And if not, why not?
No. Of course, rape and incest is one, but a lot of people aren't going to do what has to be done to get those. A lot of people don't want to go to law enforcement and talk about it. I know a lot of the times clinics don't always understand these either or know what they can and can't do. So I haven't, that I have my knowledge of, worked with anyone that has used those. And then the health of the mother is also a kind of difficult one. I've seen people who are under 24 weeks that still can't be seen just because it doesn't meet the criteria from doctors.
Mm-hmm. When you think about this amendment or the proposed amendment, how much of what your organization does, the Tampa Bay Abortion Fund does, how much of that hinges on whether this amendment passes or fails in November?
I think it's a great amendment, but I don't think it really changes what we do. I think we were here before, we're during now. And after, I think it'll be great if it does pass, and it, of course, kind of strikes down a barrier here, but for abortion funds, we're always going to be needed, and will probably be needed more if this does pass because, again, we'll go back to being a quote-unquote safe haven, so we'll have a lot of people from the South coming here.
So if it doesn't pass, that could mean something for your organization? Like, would it change what you do and how you do it?
I think it would just stay the way it is right now with helping Floridians get out of state, and then, of course, just still staying with the 6-week ban.
Mm-hmm. Opponents of the amendment say the language is confusing, and Attorney General Ashley Moody, as we discussed earlier, argued just that before the state Supreme Court. What do you think of that argument?
I don't think it's confusing at all. I think they just want to say that it is. I think viability, as was said, is around 23, 24 weeks. And then, of course, it's not taking away from judicial bypass or the 24-hour waiting period. So I think it's pretty easy for our voters to read.
Do you think this debate will ever end?
Probably not.
Catherine, from your reporting, what is the level of awareness about what the rules are now in Florida, like the 6-week restrictions, the exceptions to the rule, and kind of what people can and can't do when it comes to abortion here?
The awareness is it's spotty. I mean, I've talked to healthcare providers who have had patients come in and were surprised to learn that there was a 6-week ban. They weren't aware. And other people who are and are, very much, supporting this amendment and, getting the word out that way. So it's spotty. I think something that a couple providers brought up when I did some interviews was that the state hasn't really done any sort of like comprehensive like PSA campaign or put out any literature to help publicize that this ban has gone into effect, particularly with the way that it went into effect, that it was signed a year and a half ago. And then there was this long lag time where the Supreme Court had to rule. I mean, people are busy, and they got, jobs and families, and it's hard to follow the news. As all of us work in news know, it's hard to keep people's attention, and that's totally fair and valid. And so, it's asking a lot of people to keep up with all these different court rulings and changes in policy, and that gets really sticky and really hairy when you're talking about something as important and fundamental as someone's health. So yeah, that's definitely a critique that I've heard, that, they wish the state was doing a little bit more to try to get the word out, because there are still patients and that are not, not totally aware that this went into effect, or are confused about, well, wait, didn't we have a 15-week ban? What happened to that? And it's confusing. It's confusing for journalists to follow, and we do this full time, So yeah, I think that's a tough hurdle, for Floridians right now.
For organizations that have been focused on the kind of practical aspects of helping folks seek abortion access, are you seeing a change in that they may be now pivoting to try and get people mobilized to vote, for example, or kind of make them more aware of what's on the ballot in November?
Yeah, I mean, I've definitely, talking to providers and advocates, that is something that comes up. It's like, well, what can people do who are concerned about this? Well, vote for this amendment. I do think people are pivoting to sort of that, if not advocacy and encouraging them to vote for it, at least informing them that it's on the ballot and you can have your say. So, it's, something you could hear from your doctor, from your gynecologist, that this is, in play this November, and voters have a say, and you, if you are uncomfortable with this, or if you don't like it, you can vote for this amendment. So definitely seeing, some of that, that conversation, and with, in spaces where you may not expect it.
You're listening to Florida Matters, live from the Performance Studio at WUSF in Tampa. Bree Wallace from the Tampa Bay Abortion Fund, thank you so much for joining us. and Catherine Vaughn with Axios Tampa Bay. Do stay with us. Up next, opponents of the proposed constitutional amendment on abortion, Amendment 4, say they want to protect the lives of unborn babies and the health of mothers. You'll hear more when we come back. You're listening to Florida Matters. I'm Matthew Petty, and this conversation about Amendment 4, a ballot initiative to include abortion access in the state constitution, is coming to you from the WUSF Performance Studio in Tampa. Now, if you're voting in the election in November, you'll have the chance to vote yes or no on the proposed amendment. We just heard from a supporter of the amendment. Now, John Stemberger with the Liberty Council is joining us. His group is urging voters not to approve this amendment. John, welcome, and why should Floridians vote no?
Yeah, thanks, Matthew. First of all, thanks to the producers and for NPR. Where do we get to talk about an hour of anything? This is really a remarkable forum, so thank you for providing the space. It's basically a very extreme amendment, and it's not what it seems, and it's very deceptive. The words are very slippery.
What is slippery about them, though? Because, proponents of it say this is pretty clear, that the language is about as clear as you can get.
Yeah. No, it could be actually a lot clearer, and it's not. For instance, the fishnet ban that was passed a while back had 6 definitions. Pregnant pig amendment had 6 definitions. The indoor smoking ban had 8 definitions. Lots of amendments have definitions. The medical marijuana amendment had almost 4 pages of definitions. This amendment has no definitions at all. So with words like health and healthcare provider, it's very difficult to know what exactly that means, and it becomes very important when you look at the language. Those that are advocating for this are not really encouraging people to look strictly at the amendment and its language. We're encouraging people to read the language because it's very important to know what's being passed. And the language is very extreme, and it's very unclear as to what's going on here.
If I can sort of dig into that, the language issue, one of the claims by folks who oppose the amendment say that it would allow anyone to sign off on an abortion, even say a receptionist at a clinic or a tattoo artist. But Florida state law requires a person practicing medicine in Florida to have the requisite training or license, and it's a 3rd-degree felony, to do that without that license. So, is this a bad faith argument against the amendment?
Well, I would say that the way to summarize the amendment is it's abortion on demand for any health reason. And the amendment talks about health and healthcare providers. Neither one of those are defined. There's 4 places in Florida law where a healthcare provider is defined, and they're all defined differently. There's the Florida Insurance Code, the Torts and Med-Mal Statute, the Florida Patients' Bill of Rights, and licensed entities and entities regulated by the Florida Department of Health. All different regulations about what a healthcare provider is. Some of them do include nail technicians and tattoo artists, so it's really difficult. The court doesn't know what it's going to use for definition because it hasn't given us one.
But realistically, if somebody at a nail salon or a tattoo artist gave the go-ahead for an abortion, that wouldn't pass muster, right? That doesn't seem like a
well, if an abortion
situation.
Clinic wanted to accept it, it could. There's no definition. That's the problem with it. They could have easily said medical provider. That would have been very clear, but they removed that word. So given the current definitions of healthcare providers in the statute, all of them have, except for one, has non-medical personnel, all kinds of different people that could sign off on these things. So it's really difficult. What's more damaging is the word health itself. On the same day that Roe versus Wade is decided, there's a companion case called Doe versus Bolton. It's a hospital case, and the Supreme Court of the United States is saying, what is health? And they use a very broad definition: physical, emotional, psychological, familiar, and even a woman's age. That's the same kind of definition we get from the World Health Organization that talks about a state of complete physical, mental, and social well-being. So, every pregnant woman has health symptoms of some type that change, right? Back pain, vomiting, cramping, bloating, weight gain, mental stress. So these are all health issues which under the amendment could be protected by getting an abortion.
Right,
so it's really abortion on demand for any health reason.
But it would be up to the medical care provider to make a...
It's not a medical care provider. That's the whole point. It's a healthcare provider, which could be a non-medical provider.
But nonetheless, it would be up to somebody who was trained adequately in the right way to provide that level of care to make that decision. I think that's the argument that you will hear from folks who say this amendment is a good one, and this is why. Like that they're saying that the kind of discussion, the back and forth over that terminology is maybe not the best faith argument to be made. The other question I had for you, though, is,
Sure.
I mean, in the past, the Florida Legislature has stepped in and regulated amendments that have passed, like the amendment that allowed people who'd served felonies to vote, or the amendment that had legalized medical marijuana. I mean, you mentioned the definitions, but there was a lot of kind of litigation of those, and they didn't necessarily roll out immediately because the legislature got involved. So why would this be any different if it passed?
When you enshrine an activity in the Constitution, you create a fundamental right. Any state action which burdens that activity or attempts to restrict it or prevent it in any way is going to be struck down because it now becomes a very superpower. The professor can talk about the standards for a fundamental right when he comes up here to talk. But basically, you have a situation where you can't, if you have freedom of speech, freedom of religion, these are all fundamental rights. States' laws that burden those rights are going to be struck down unless they can provide a compelling state interest, least restricted means. So they're very powerful rights. So it's going to be very hard for the state to come in and say, well, we want to regulate this because the statute says no law shall prohibit, penalize, delay, or restrict abortion. Well, laws that provide certain limitations on abortion, whether it's waiting periods or parental consent, or even laws that prevent late-term abortions, restrict abortion, they delay abortion. So the amendment is very broad, it's extreme, and Floridians have different views on this issue, right?
Sure.
But this amendment is going to provide abortion for any health reason up through all stages of pregnancy.
Again, I mean, any stage of pregnancy, that's an argument that, healthcare providers, abortion clinics, and the folks who provide this kind of care would push back and say that's kind of taking it to the nth degree, and that doesn't actually happen. I mean, the case of people, seeking abortions, very late in pregnancy is pretty rare.
It is rare, but it would be legal under the terms of this language because it is so broad. And look, abortion industry, they're in this for the money. This is a multi-million-dollar business. And these doctors that do these abortions, these are not the most ethical physicians. These are often physicians that are very difficult in terms of ethical behavior and the way they operate.
Do you really think there are people making millions off this, though?
Oh, absolutely, absolutely.
We've heard folks say, look, they're running out of money to kind of help people get this care. It doesn't sound like a place
abortion is a multi-million-dollar industry. You can look at the Guttmacher Institute, which is the Planned Parenthood's own research arm, and it'll tell you that how much money is made on abortions.
There have been some cases where, doctors are reluctant to perform an abortion even when the mother's life is in danger because they're worried about the legal risks. Like in Idaho, for example, there is a near total ban on abortions. And there was a case where a woman sued the state after she sought an abortion in Oregon because her fetus had a condition that would have led to stillbirth or miscarriage. So does there need to be some language to help kind of clarify what the exception is in current law under the 6-week restriction?
No, I think that, first of all, let me just state clearly what the exceptions are, because I don't think we've had a clear explanation. There's two parts of exceptions. For the first 6 weeks, it's rape, incest, human trafficking, life of the mother, fatal fetal abnormalities, certain conditions which the baby's going to die anyway within a certain period of time after birth. Or the final one, to avert a serious risk of substantial and irreversible physical impairment or major bodily function of the pregnant woman other than a psychological condition. There's no health here at all. I heard the word health exception several times. There's no health exception in it. Now, after the first 6 weeks, the exceptions for rape, incest, and human trafficking are gone. But for the first 6 weeks, those are the 6 exceptions that are in the statute. And they're very clear. In the reporting requirements, there's no requirement. I mean, it could be anybody. Like you have to go to a police report. It could be a doctor's report. It could be a note from a social worker. There's really no indication of what kind of report it has to be. It has to be some kind of documentation that there was rape or incest or human trafficking.
As we've heard, like those kind of conversations can be very difficult to be had from somebody who's a survivor of rape or incest, right? So, I mean, should there be some more clarity? Should there be a little more flexibility there?
Well, it's not defined. It could be any documentation. That's the thing. I had an exchange with a reporter about it. She said, why is it so broad? I said, because we want it to be broad. We just want to provide some basis that it's legitimate, right? It's not just somebody using it as an excuse or lying. There has to be some basis for the fact that there was a rape, there was an incestuous relationship, or there was some human trafficking. So it has to be some documentation from a physician, a counselor, a social worker, somebody, so that it's legitimate.
some physicians have said, like, even when there are exceptions written into a rule, like restrictions on abortion, they're reluctant to provide that care. Or they may be reluctant because they're worried about, what their liability may be.
Abortion physicians are not concerned about liability. These are men and women that do this.
But I mean, some of them say they are. They've said that.
Maybe in hospitals, but the vast majority of abortions are performed by physicians that are flown in. They go around the country. They're not local doctors for the most part. Some of them are, but that's not an issue. It's just not an issue. With credible doctors are not doing abortions. You're going to have the lowest of the low of physicians that are doing abortions.
That seems like a pretty out there statement to make.
If you want to look at the documentation, it's there. Criminal activity, sexual activity, all kinds of unethical behavior going on in these clinics. It's really quite atrocious.
We may have to do some fact checking on that. But let me put a question to you, Catherine. I mean, the notion that clinics are flying in physicians and that there is some kind of level of nefarious activity at abortion clinics. What have you heard in your reporting?
No, it's just that oftentimes it's not a local doctor. These are doctors flying in from out of state and from various places they come for a weekend, they'll do the abortions in a facility, and then they'll fly out again. That was my only point.
I have not heard of that or seen any evidence of that in my reporting. The providers I talk to work at Planned Parenthood clinics in Florida, in the state, and in also in private practice in Florida and the state. I have not heard of this flying in doctors. I am not familiar with that, and all the providers I've talked to work in state and have for quite some time. So I don't know that there's any evidence of that.
Well, it does also seem to run counter to what we're hearing from the folks who are providing abortions or helping people access abortion in Florida, that there is now people having to leave the state because of the restrictions in Florida. So those two things don't seem to add up. Anyway, let's move on. John, I'm wondering about some of the other kind of questions around, the legislation, and if this amendment passes, I mean, what do you think will change? Will this debate end?
Well, what will happen is you'll see an immediate legal challenge to parental consent. You'll see a challenge to the 24-hour reflection period, where we're asking a mother to simply look at the informed consent and think about this weighty decision that's irreversible, that can't be changed, it's permanent. You'll see challenges to the limitations on when abortions can have. Again, the amendment very clearly states, no law shall prohibit, penalize, delay, or restrict abortion. Those 9 words are really summarize the essence of the amendment. And so you'll begin to see legal challenges for all these things. And we've seen in other states, in Ohio, where their abortion amendment passed, they're challenging parental consent laws. In Michigan, they're actually challenging the laws which prohibit public funding from going to fund abortions. This is now in the actual financial statement itself, because we've seen this in other states. We've seen this play out.
So your work won't end, or the work of the folks who are kind of bringing a legal challenge to this and challenging the amendment itself, that's not going to end in November, no matter what happens.
I don't think so, no.
And if I could just jump in really quick on
Sure.
the 6-week, on the rape and incest exceptions of the current 6-week ban, the law says, as far as the documentation that you would need to provide evidence of being a victim of rape or incest or human trafficking, is she must provide a copy of a restraining order, police report, medical record, or other court order or documentation. So providing evidence that she is obtaining the termination. So I just want to note that there is explicit direction on what kind of documentation you have to provide to furnish evidence to get that exception.
There is an additional debate happening too, Catherine. All proposed amendments include a financial impact statement that analyzes the potential cost, and the one accompanying Amendment 4 has itself been the target of lawsuits for being outdated and ambiguous. Does that sort of muddy the waters a little bit for voters, that financial implication statement?
Yeah, I mean, it can certainly. I think, it's a lot to think about that the state is saying that, they plan to challenge this amendment if it passes. It's sort of a lot of hypotheticals to kind of think about when you're at the ballot box. And there's also, I believe there was an aspect of wanting to say that abortions could, public money could start going toward abortions and funding abortions, but Florida does have a law prohibiting that on the books at this point. So it does, it just gives more voters more, more information, that they'll have to, grapple with and make their own decision. But it's certainly, it adds on to what is a pretty concise amendment, a lot of extra information that, that could be confusing.
As we've witnessed, there's very distinct arguments from supporters and opponents over Amendment 4. Catherine, what would your advice be to how Florida voters can learn more about the issue before November?
I think that, looking to your local newspaper, looking to, credible sources, journalists, information, reading the amendment for yourself, and making sure that the facts is really important, and keeping facts front and center, that you understand, the definition of viability, and just seek out information that from credible sources. I think that's and doing research for yourself.
You're listening to Florida Matters live from the Performance Studio at WUSF in Tampa. John Stenberger with Liberty Counsel. Thank you so much for joining us, John.
Thank you.
And Catherine Vaughn with Axios Tampa Bay. Please stay with us. The conversation about Amendment 4 on abortion access in Florida continues after this. More details on the constitutional amendment. You're listening to Florida Matters. I'm Matthew Petty, and we're live from the WUSF studio in Tampa. Even before Amendment 4 made it onto the ballot, there were disagreements about the language. Attorney General Ashley Moody argued it would confuse voters. In a brief asking the state Supreme Court to keep the amendment off the ballot, Moody said it would, quote, lay ticking time bombs that will enable abortion proponents later to argue that the amendment has a much broader meaning than voters would have ever thought, end quote. Well, to help explain what the amendment says and what it doesn't say is Louis Varelli. He's a professor of law at Stetson University College of Law. Louis, thank you so much for joining us.
Thank you for having me.
Opponents of the amendment say it's open to interpretation. Is it?
Well, everything's open to interpretation, but I don't think in the way that Attorney General Moody suggested. I think the amendment is actually a very straightforward explanation of what it's trying to achieve. And for those of us that have been following the jurisprudence of abortion for decades, it's a pretty clear statement of effectively the holding in Roe v. Wade.
Is there a way, or would there have been a way to write this amendment so that it isn't open to claims of vagueness or misinterpretation or the kinds of challenges we've seen so far?
In this climate, I would suggest not. There may always be a better way to word something like this, but I think having read a lot of these and having taught this course for a long time, reading this amendment is pretty straightforward to me. I understand exactly what they mean. And the reason I feel confident saying that is not because I'm special, but because the terms of art that people are concerned about are in fact terms of art. They are constitutional law terms that have existed since Roe was decided and have been repeated by courts since. So, for example, viability has meant 23 or 24 weeks since 1973. There can be debates about whether it should mean that, but it has meant that since 1973. In knowing that, the use of the term viability in the amendment, I think, is a useful legal term that judges will understand.
But for people who haven't been paying close attention to this, as you have for many decades, is there a chance for confusion to sneak in?
Well, perhaps, and I think that's why programs like this are so useful, right? So an important thing for voters and their listeners to remember is that judges will have lots of opportunity to interpret this amendment. That's what constitutional law is. It is the use of a relatively general document. The U.S. Constitution is only 14 pages long in certain fonts, that is interpreted by the judiciary. So judges will have an opportunity to visit words like viability. I think the point at this stage of the process is, do we have reasonable, or in this case, sufficient certainty to understand what the amendment is getting at? And I think very clearly we do. The prohibition on, or the language that says prohibit, penalize, delay, or restrict abortion is followed immediately by a qualifier that says before viability. That is what Roe said. From 1973 until 2022, when the Supreme Court overturned Roe, the law in America was you cannot prohibit an abortion before viability. People of my age have lived under that regime their entire lives. To protect maternal health was also a holding in Roe. So since 1973, a state can prohibit abortion after viability unless maternal health is at stake. Is that a tricky term? It could be, for sure. And judges have had to think about that term, and legislatures have had to think about that term. But it's not a new standard. We've been dealing with this for half a century.
Right. I mean, there's as you say, there's kind of some back and forth over the word viability. Also, as we heard, definition of who is a healthcare provider, what that means. But what level of detail can you put into amendment before that becomes confusing for voters? Like, is there a sweet spot between brevity and comprehensiveness, I suppose?
There is, but I would suggest it's slightly more art than science, right? So from what I know, and my friends in the press will have a better idea of this, of the amount of money and time spent crafting this language, knowing full well it was going to be challenged at the Florida Supreme Court. This, in my view, as someone who focuses on the law in this area, not the politics, is that this language is as transparent and as clear as someone seeking to set an abortion standard that protects abortion at all could be.
I wonder if you could talk us through the financial impact statement that accompanies the proposed amendment. We've mentioned it earlier in the program, but does that add a layer of clarity, or is it kind of adding a layer of opaqueness?
The financial statement in this situation was a little unusual. So financial statements in other contexts have been done sort of in more of an economic analysis way, in the sense of this policy choice made by the amendment will cost people this because of the way it affects our lives. The financial statement in this amendment was largely based on litigation costs. Of course there's going to be litigation about this. The litigation is going to come when the legislature passes laws about abortion and they are challenged for violating the amendment. So, for example, a parental notification law will not be one of those because that's protected by the amendment, but a parental consent law will almost certainly be enacted by the legislature, or certainly could be, right? I'm not prescient in that regard, but there is one now, so I would imagine the same legislature would be interested in a parental consent law. That's going to be challenged for violating the amendment. There's no reason to believe it will be struck necessarily. That'll be up to the Florida Supreme Court, and we know, generally speaking, the Florida Supreme Court has not been overly permissive with abortion rights based on their April 1st decision of this year. So we're going to have those challenges, but that's true in every amendment. I cite the felon enfranchisement amendment, right? The felon voting amendment led to a lot of litigation. That's always true. So to the extent the litigation is driving the costs, right, there was a lot of litigation around the 15-week ban, and that didn't seem to be sort of something that the state balked at. So this is going to happen. Will it cost real money? For sure. Is it unusual? No, and it's not really attributable to the abortion access issue that the amendment's targeted at.
If the amendment passes, do you see the Florida Supreme Court having a say in how it's implemented?
Without question, right? That's what's going to happen. So you're going to have the legislature. So it's important that people understand what an amendment does. It does set a floor of a basic right. And the right here, as I read it, and I think is, from my perspective, very clearly states, prior to viability, abortion may not be prohibited. Now, that was true under Roe, and under federal law, under Roe, parental consent was required. The U.S. Supreme Court read Roe, interpreted Roe, and said a parental consent law in Pennsylvania is okay because it doesn't burden abortion enough to be unconstitutional. So we've been through this, as I say, for 50 years, and it isn't necessarily true that the amendment wipes the slate clean. None of our rights operate that way under the Constitution. So there will be efforts by the legislature to legislate abortion. Those will be challenged by people who don't like them under the amendment, and ultimately the Florida Supreme Court will be the final word as to whether those laws comply with the amendment. That's a really important thing for people to understand, right? This amendment doesn't work magically in our lives. It is a baseline against which legislation from the Florida Legislature will be judged, and that still remains to be seen.
It's not the first proposed constitutional amendment to generate a lot of media coverage. I mean, you mentioned the enfranchisement of folks who've served sentences for felonies. That's one of them, and then of course medical marijuana. There was a lot of litigation around that, and there's strong opinions on this one on either side as well. It's kind of from a legal standpoint, how consequential is this proposed amendment?
In terms of the current state of law in Florida, it's quite consequential. But the way I would describe the legal environment this amendment describes, from my perspective, is pre-2022 in Florida. It's actually more restrictive than that because Florida's constitution until April 1st of this year was more protective of abortion rights. It allowed more access to abortion than the federal constitution did. But this amendment effectively enshrines the Roe v. Wade regime. And I know that, or I think that, because the language used in the amendment parrots the standards that began in 1973 in Roe and carried through all of the various permutations of the Supreme Court in 1992 in a case called Casey, and in cases after that. These fundamental features of the abortion doctrine in America never changed. Pre-viability abortion was overwhelmingly protected. Post-viability abortion was not, unless maternal life and health was at stake. And that's the way I read this plain text, what this amendment will do. So if people are trying to just think of what their lives will be like legally, it will be the way your life was, the way you experienced the law of abortion from 1973 to 2022.
Catherine, after Roe was overturned, you reported on Florida's privacy clause and how that was used to protect abortion access until Florida's 6-week ban was rolled out. So what does that tell you about how laws are interpreted, I guess, including constitutional amendments, as we've been discussing?
Yeah, so the privacy clause was really the sort of issue that the Supreme Court was looking at, assessing the language of the 15-week abortion ban. And it's really broad. I don't have the language in front of me, but it's very broad. It guarantees you So every natural person has the right to be let alone and free from governmental intrusion into his private life, except as otherwise provided herein. That's a really broad amendment protecting privacy. What does privacy mean? Of course, that's very up to interpretation. And it was interpreted by the Florida Supreme Court to protect abortion access. There were 2 court rulings, one, I believe, in 1992, and then another one affirming it. But yeah, that's what the Supreme Court this year overturned that precedent and said, no, the privacy amendment actually does not protect abortion access. But yeah, the reporting I did a couple of years ago was about the framers of the privacy amendment and having interviews with the original folks who drafted that amendment. Their takeaway was that the main sort of driver behind it was an FSU law professor named Patricia Dorr, who saw it as an insurance policy in case Roe v. Wade was overturned, and that she wanted to make sure there was something in the Constitution protecting abortion access. There's certainly room for debate. There, the historic record doesn't have. The historic record deals a lot with informational privacy and, data privacy, not necessarily abortion. But ultimately, what the framers intended isn't really as important as what the voters thought they were voting on. So voter intent is more important. And the Supreme Court, of past ruled that abortion was part of those privacy protections, and the Supreme Court currently said, actually, no, abortion isn't part of those privacy protections. So it really shows how the courts, how much courts can change over time.
Well, the issue of what it's more important what the voters think than what the kind of framers think. I mean, that sort of speaks to the discussion around this particular proposed amendment, right?
Right. So what I think is, and what I've been telling people I think is most interesting and important about this vote, regardless of how you want this to come out. So I want to be clear. The fact that I think the amendment clearly states what the law will be is not meant to be an endorsement either way of how I think people should vote. I don't think the amendment is confusing based on sort of the language it uses and why it chose that language. But in terms of the choice in November, the Supreme Court of Florida created a very simple calculus. Right? When they made their decision on April 1st about the 15-week ban, they didn't have to read the Florida Constitution to not protect abortion rights at all. What they had before them was a 15-week ban. They could have just said the 15-week ban is okay and moved on. They made a bigger decision, and that's their prerogative. They are Supreme Court justices. They reread the Florida Constitution differently than it had been read since 1989 to say there is no protection for abortion in the current Florida Constitution. What that does is it wipes the slate clean. It doesn't mean that there aren't any protections under law. There's a statute, but the Florida Constitution is not currently protecting abortion. The amendment being voted on November does protect abortion up to viability and after viability when maternal health or life is threatened. So that simple choice is very unusual from my perspective as a Floridian for almost 2 decades now. Florida constitutional amendments I found to be in the past confusing sometimes, right? It's not always clear to me over the last 20 years when I'm voting on an amendment what it means. I don't think that we have that problem this time. I think if you are in favor of abortion not being available after 6 weeks, or you're in favor of the current state of Florida abortion law, a 6-week ban with exceptions, then you should vote no on the amendment. If you are in favor of an abortion regime that looks like Roe v. Wade, then you should vote yes on the amendment. And I think that is helpful to voters, and I'm hoping will be encouraging to them to go exercise their franchise, to go vote, because you have a pretty clean choice. If the Florida Supreme Court had done something slightly different on April 1st in their decision this year, they could have made this much more difficult a choice, or at least I don't mean difficult in terms of being torn about what to do. I mean more complicated of a choice. This is a very stark choice. No constitutional protection for abortion in Florida, constitutional protection up to viability, and then afterwards for maternal life and health, see Roe v. Wade.
Well, you've been listening to Florida Matters live from the WUSF Performance Studio in Tampa. Louis Varelli, Professor of Law at Stetson University College of Law, thank you so much.
Thank you for having me.
And Catherine Vaughn, reporter with Axios Tampa Bay, thank you.
Thank you.
Thanks to Florida Matters executive producer Grayson Doctor, our engineers Dave Anderson, Jackson Harp, and Blake Bass. Thanks also to Mary Shedden, Julio Ochoa, Leslie Laney, Stephanie Colombini, Warren Buckholtz, Scott Wachtler, and Chandler Bolcom, and our audience in the WUSF Performance Studio in Tampa. I'm Matthew Petty. You can subscribe to Florida Matters wherever you get your podcasts. Thanks for listening.